number 52, the people of the state of New York versus Carlos Torres. Counsel?
Good afternoon. Catherine Skolnick for Appellant Carlos Torres. I'd like to reserve 2 minutes for rebuttal, please.
Of course.
Thank you.
You're welcome.
While the New York City Council had laudable goals in enacting Administrative Code 19-190B, it used inappropriate means to meet them. That provision, which criminalizes a negligence tort, is preempted by both the Penal Law and the Vehicle and Traffic Law. Penal Law Article 15 spells out 4 exclusive mental states, plus a very limited strict liability exception applicable to all crimes. Ordinary negligence is not one of them. The minimum is gross negligence, which requires socially undesirable conduct and a failure to perceive a substantial and unjustifiable risk. And Penal Law 5.05 subsection 2 states, the provisions of this chapter, that is the penal law, shall govern the construction of and punishment for any offense defined outside of this chapter. In other words, these 4 mental states apply to all crimes in all chapters.
Counselor, how would you reconcile Feingold?
Well, Feingold simply brings in an additional mental state that must be proven, but recklessness is one of the 4 enumerated mental states, and that appears in the statute that was at issue in Feingold. So essentially, what Penal Law Article 15 has said is that at minimum you need one of these 4 mental states. And here we have the due care provision, which essentially criminalizes something that someone does with no, not any of these 4 mental states.
So, counsel, there are other misdemeanor offenses that impose criminal liability based on a civil negligence standard. What is VTL 1212, which is the reckless driving section, and doesn't the existence of 1212 foreclose your argument on preemption here?
Well, no, again, 1212 requires recklessness, and that is one of the 4 enumerated mental states, recklessness as to driving. Some of the other examples that both the district attorney's office and the city cited all contain at least one of those 4 mental states, even if they also require an additional mental state.
Can we take stepping outside the mens rea argument for a second? I'm asking a question about constitutionality now. If 1990 were a strict liability offense, would you be challenging the constitutionality of the ordinance?
We might, well, I think that, first of all, it isn't. There is the...
Well, no, stay with my question, not yours.
But I think the problem here is that...
No, would you be challenging the constitutionality of the ordinance? Because if you wouldn't, then you're in a different situation on the constitutionality question.
Well, it depends which constitutionality question. As to penal law preemption, perhaps not, because it does allow for a strict liability exception. But there's still the overlay of vehicle and traffic law preemption, where the vehicle and traffic law, subsection 1600 and 1604, both state that what the state enacts here is supreme, and any local laws that conflict with it must yield.
Okay.
So there is that possible constitutional challenge.
I see. Thank you.
So getting back to the initial argument, this court has found that Article 15 applies to non-penal law crimes. And as further evidence, the Bartlett Commission, in adopting the penal law, said that gross was greater than ordinary civil negligence, and even gross negligence was to be used sparingly. The common law, too, has long said that more than simple negligence is required for criminal liability. Undergirding this is the idea of moral fault, and that courts must be careful in interpreting laws that impose criminal liability. And again here, the potential is to impose liability for something that people do every day, for quite ordinary conduct. As I was...
Can I just ask a simple question, I think, about your preemption argument? Are you making it only with regard to the city's ordinance or also with regard to VTL 1146?
We're not making it with regard to 1146 for several reasons. One is that Mr. Torres was only convicted of the infraction at the state level, and our argument is that what was problematic here was that the city made something a crime that the state had not.
The
So that's why
infraction still allows for 15 days of jail time, right?
The infraction?
Yeah, the state infraction.
I believe that's correct.
Okay.
So the core of your preemption argument then, I think on conflict preemption is that, that this law cannot impose a stricter penalty than the state law regulating the same subject?
It's slightly different than that.
Okay.
It can impose, our argument is not really about penalties, but rather about criminalization. So the state has said that this nearly identical conduct is simply a traffic infraction, where the city has said that it's actually a criminal offense. It's a misdemeanor.
But doesn't it have an additional element? I mean, you have to have violated the right-of-way of the bicyclist or pedestrian, right? So it's not the same crime.
It's not identical. There is that additional conduct, but making turns, changing lanes, these things are all ordinary, everyday activities, and they're really no more or less dangerous than most other aspects of driving.
But to stay with the conflict issue, though, I mean, it's not identical. So you have an additional element of the one crime, right? So,
Well,
they haven't really criminalized, I don't see the conflict then.
Well, the other piece is that the city actually makes it a crime to cause physical injury, whereas the state says you have to cause serious physical injury. So in a sense, there are some distinctions, but...
But again, a serious physical injury doesn't take into account a right-of-way violation, right? So it's not the same. It's not as if they were criminalizing the same conduct differently, which is a different issue, and there are arguments that you can do that, but just to stay with this argument.
Sure, there are some slight distinctions in the statutes, but again, a lot of what is covered by what the state has prohibited is also covered by what the city has prohibited, but the city has made that conduct a misdemeanor, and that's the core of our conflict preemption argument. But really, the main argument that we're making here is that...
But see, let me stop you there, because I don't think that is the same, because the way I understand 1146C1, which is a traffic infraction, is only becomes a misdemeanor after there have been successive convictions within a 5-year period of time. And that's different from what we have here.
Well, we're not necessarily actually dealing with 1146D, because that is, as Your Honor pointed out, the recidivist provision. So what the state has said is that when you commit something more than once, that might be a misdemeanor. And the city has said that only on doing it the first time is it a misdemeanor.
But Counsel, you were saying what your main argument was. I know your light's on. I wanted you to get to that.
So the main argument here is that the statute is clear, the city statute is clear in its terms that it is prohibiting acting without due care. And the penal law says that, penal law 15.15 and 5.05 taken together basically state that to make something a crime, and that provision applies outside of the penal law as well, you need one of those 4 enumerated mental states.
And that would apply whether it was the city or the state enacting a law outside the penal law.
That's correct, but we're arguing that as to Administrative Code 19-190B, there is that preemption problem in that the penal law is supreme over what the city is permitted to do.
Chief, may I just ask one more
Yes,
question? On a different topic, you're asking us to undo the plea based on the failure to give the term of the conditional discharge. There was some indication in the appellate term that you were only asking for that with a dismissal. Is that still your position here?
No, we do feel a dismissal would be appropriate under People v. Burwell. Mr. Torres has completed his sentence. He has no criminal record. But if the court declines to do that, then it should reverse and remand for further proceedings.
Thank you.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. Samuel Goldfein on behalf of the people. Administrative code is constitutional statute. It constitutionally imposes criminal liability on the basis of the failure to exercise due care. I think as a preliminary due process matter, strict liability crimes are permissible in this country, and if you can impose criminal liability on the basis of no mental culpability whatsoever, you can impose criminal liability on the basis of some mental culpability without running afoul of the Constitution.
What about the argument that the penal law preempts this?
Yes, so thank you, Your Honor. So I think if you read the penal law sections, the first thing to point out is that the legislature is able to distinguish when it wants a provision to apply to the penal law only or when it wants it to apply outside. So the definitional sections in 1500 and 1505, those both apply to this chapter, the penal law. When the legislature wants to say otherwise, it states so, like in 1515-2, where it says this applies both in and outside this chapter. I think the best example of the true legislative intent is what the legislature has done in the years since the enactment of this provision. So in 1965, the same year they passed the penal law, they also codified Agriculture and Markets Law 370, which makes it a misdemeanor to fail to exercise due care in the keeping of wild animals. So at the time, the legislature believed that a non-1505 mental state was permissible for a criminal statute outside the penal law. Much more recently, with 1146D, the legislature again criminalizes, makes it a misdemeanor to fail to exercise due care. So I don't think there's any legislative intent here to occupy the field of applicable criminal mental states. They're allowing these other states, they're passing them themselves. Plainly, the penal law doesn't supersede the VTL or the Agriculture and Markets Law. The state is not superseding itself. So just as a matter of the penal law. As far as the VTL preemption argument is concerned, VTL 1642A gives an express and very broad grant of authority to the city to pass exactly this type of legislation. It actually goes so far as to say that if there's a conflict, the city ordinance shall supersede the state statute. It's going to control. So under those circumstances, and 1642A, 10 and 11 both say explicitly the right of way, the rights of pedestrians. I mean, it's exactly the context we're talking about.
Well, it doesn't actually say anything about criminalizing anything, right? So you could read, I'm not saying I do read it this way, but you could read regulation of traffic and rights of way and so on to be where the crosswalk is going to be, how far back it's going to be, those sorts of things.
Well, absolutely, Your Honor, but I do think that this, because of how broad the grant of authority is and because it allows it to supersede, it's reasonable to expect the city would legislate and regulate.
What about VTL 155? Which defines traffic infractions?
Yeah, right. So I think that allows for if otherwise authorized by statute, and I think 1642 is the express authorization for a city with a population in excess of 1 million. And as I was saying, I think that the city or the state should have expected with this broad grant of authority that the city would regulate using similar tools, namely penalties, some of which are criminal, some of which are strict liability. And here, in this particular context of the right of way, the city is regulating using identical language. I mean, this due care language comes directly from the state provision. They've taken it and they've put it into their statute. They've elevated the penalties. They've made a first-time collision a crime as opposed to just a violation. But the state statute still criminalizes the exact same actus reus and mens rea as a misdemeanor. So if there are no further questions about the VTL, the administrative code provision, I would turn briefly to the conditional discharge length.
Please.
Yes, so the first thing I would say is that this court has never found that the length of a conditional discharge is a direct consequence of a guilty plea. I think that there is a very significant difference between the length of a conditional discharge versus the length of probation or PRS or even a prison sentence. In the latter context, the length is the most immediate direct consequence, the most penological, the most significant consequence the defendant is going to face. How long are their liberties going to be restrained? How long are they subject to enhanced scrutiny and supervision? In the conditional discharge context...
What about a conditional discharge where common one on DWI is you put an ignition lock on the car?
Yes, Your Honor. I mean, there are some more stringent conditional discharge requirements, but overall they're much less onerous and much less likely to get the defendant into any kind of trouble than...
I'm drinking and driving. It's a real problem to get the car going, though, if I have that ignition lock on.
Well, absolutely. I take Your Honor's point, but the penal law authorizes much more stringent restrictions on probation. You have reporting requirements. Your officer could come to your house. There's electronic monitoring. I think that the context
is there any basis for distinguishing between the severity of the limitation?
As opposed for whether or not to sentence them to probation or conditional discharge?
Yeah.
Certainly that's a consideration for the judge and when negotiating the plea in a case like this. But I think in the conditional discharge context, the length really serves as a deadline more than anything else. You have such and such a time to complete the conditions, which are the immediate and direct consequence for the defendant. He has to, in this case, pay his fine, complete his driving program.
Do we need to get to that issue if it's not preserved?
Sorry, Your Honor?
Do we need to get to that issue if we conclude it's not preserved?
On the challenge to the conditional discharge?
Yes.
Your Honor, I mean, I believe that Yes, he pled and was sentenced at the same proceeding, but there was here a practical opportunity for him to object. He was informed of the length of the conditional discharge, albeit moments after he pled guilty, but he was asked if he understood. He stated that he did. And as Your Honors pointed out, even on the appellate process, he has not asked for his plea back, I guess, until right now. He's asked for dismissal, which is an inappropriate remedy given penological considerations.
If we agree with your views, does he have an argument that his counsel was ineffective?
I don't believe so, Your Honor.
Because,
I believe counsel made an argument. It was an intelligible argument. He did his best for the defendant. I don't think there's been any suggestion that counsel was ineffective here.
well, I'm trying to get to something else because you didn't mention the form. I mean, if his argument is I didn't know, I didn't realize because my lawyer didn't tell me,
Right.
right? Would
Yes,
that-
well, in that case, Your Honor, yes, he has the form. He signed the form. It states all the conditions. It's spelled out very plainly. By signing it, he acknowledges that he understands all of the conditions. So again, I think that on this record, it's plain that defendant's plea was knowing and voluntary. He was aware of these.
Weren't the conditions met before the expiration of the CD?
Absolutely, Your Honor. The conditions were met.
I have a question just about that, and I'm just
Sure.
a little confused. The sentencing date's September in 2017, and the judge at the end says November, right?
Yes,
And that's to complete the driving course and to pay the fine.
correct, Your Honor.
Then on the form that's signed, I think the same day, and signed by the defendant, it says conditional discharge term 1 year. Are there any other conditions in that 1 year other than the ones that are supposed to be met by November?
There's a general order to be a law-abiding citizen, which I think applies to all citizens regardless of whether or not you have it in writing from the court. But other than that, no, Your Honor.
But, so I guess the question really is, so if he violates that condition in the 1 year, what happens?
Well, as a practical matter, it doesn't happen. No one gets violated on a conditional discharge. The penal law authorizes serving the remainder of the sentence. In this case, it would be a couple days in jail. I think that's a very different consideration in the probation or PRS context where the violation itself is a crime. He's immediately serving the 6-month minimum sentence even if he has 1 day left. I think that's just a recognition that these are different criminal penalties and the importance to the defendant is different.
I guess the bottom line, though, is the year term is still there despite the fact that he will have completed those two conditions by November under the terms of the agreement, right?
Yes, Your Honor.
And then there's something about a December control date or something?
Right, so as a practical matter, at least in Manhattan, judges typically give a 61-day compliance adjournment to complete whatever the conditions are, the programs, et cetera, pay the fine. I think that's what the day gets up. I think on the record, the judge maybe misspeaks or gives the wrong number, but I think the math checks out that the December date is 61 days out.
So if that, on that date, can they just then end the term of the condition? Does the judge have discretion to do that?
I believe the judge would have discretion to do it. I can't see any reason why they would.
Thank you, counsel.
Thank you. I ask that you affirm and find the statute constitutional.
Thank you. Counsel, what about that language that your colleague referenced in 1642A10, the VTL? 42A10 in the VTL.
So it's true that, that the city does have the power to regulate right-of-way, but 1600 and 1604 both provide an overlay in saying that the provisions of this chapter, the VTL, shall be applicable and uniform throughout the state, and no local authority shall enact or enforce any law in conflict with the provisions of this chapter. So that is still providing language suggesting that anything that the city does with respect to right-of-way still has to comport with what the state has enacted.
Counsel, your argument isn't, just to go to something Judge Wilson said, your argument isn't that the city can't make a criminal traffic violation. It's this specific one has issues, right?
Correct. The city, as long as it doesn't conflict with
Right.
what's in the vehicle and traffic law.
There's no blanket prohibition on that.
No, and for instance, the district attorney's office drew the analogy to drag racing, and one reason we think that that's inapt is that the state and the city there both made drag racing a misdemeanor. So it's not that the city can't do it at all, it's that the city can't do it here and with this language. I also just want to touch on some of the plea withdrawal points since those came up.
Can I just to clarify this point you just made in
Sure.
response to the question from the bench? Your position is that the city can't conflict, so if the state has already criminalized it, all the city could do is impose a heavier penalty.
Correct.
correct? So it's not really about can they choose to criminalize, it's already been criminalized, it's that they could impose a heavier penalty through their own separate local law.
They could, but here what they did was.
No, I
create-
just wanted to clarify that that was your,
Yes.
that was really the fundamental point of your response.
Yes.
Okay.
As to point 2, first of all, it is within the Tyrell Lowry preservation exception, so there's no problem with reaching the issue here. But I also just want to point out that the length of the sentence,
What
It-
about the form? The form itself says it's a 1-year, that's the period on the conditional discharge.
it does, but that wasn't, I don't believe that was given to him in advance of, before he agreed to plead
Do you
guilty.
think the form is totally irrelevant to the analysis?
I think so. I think that, he, especially given that there are these other dates mentioned in December, it needs to be clarified for him exactly what conditions need to be met when, how long the term is, and that
So
wasn't
what's he
done here.
subject to past the 6 months? What are the other conditions?
To remain a law-abiding citizen, and while that does apply to anyone
Was that
at
said
any-
during the colloquy?
I don't recall if it was. But the term length has to be stated, and he has to be advised that that's how long he must do so, not because it isn't self-evident that we all have to abide by the law, but because he is subject to incarceration during that period. He can be resentenced, he can be reincarcerated, and despite what my adversary said, I have seen violation of conditional discharge proceedings take place. They do occur, often when someone is rearrested, but they're not just facing the consequences for the rearrest, they're also facing the consequences for the instant offense. And I just want to point out that regardless of the outcome on point 1, the second point is one that this court must reach because the remaining traffic infraction, of course, was something that he pleaded to, and our first argument does not apply to that. So if the court agrees with us on point 1, the remaining traffic infraction still had the plea voluntariness problem with it. And if the court does not find the administrative code provision unconstitutional, it still must reach the plea withdrawal point as to.
But the
as to
defendant
both
never
charges.
asked for vacatur of his plea until the reply brief, is that right?
No, he did ask for vacatur of his plea
Yeah.
in the opening brief.
Okay.
But he just didn't ask for dismissal.
We clarified the remedy request in reply, but again, we do feel that.
Counsel, just to the point on the drag racing, when you're speaking in response to Judge Rivera, I thought your argument on this in part was that it was the same conduct that was penalized more severely by the city was one of the reasons it was bad, but I thought in response to her question you said with drag racing, they could penalize that more severely at the city level. Did I misunderstand?
So in both cases, at both the state level and the city level, the conduct was made a misdemeanor. And so the penal law and the vehicle and traffic law preemption arguments that we made here, you can't draw the same analogy.
So it's the classification that you were arguing.
Right, and that it becomes a crime at the local level here, which is the problem.
Thank you, counsel.
Thank you.